When you file bankruptcy, a bankruptcy estate is created. What that means is you don't own anything anymore. Your bankruptcy estate owns everything that you own. There are a series of state law exemptions that we use when we file a bankruptcy. If we exempt something from the bankruptcy estate, it doesn't become part of the bankruptcy, and it means you get to keep it. If we exempt everything that you own, you are what we call a no asset bankruptcy, and it means you get to keep everything. Now, it depends on the state you're living in. Each state has their own exemption scheme, so you're going to have to talk to a lawyer in your state to determine whether or not your assets are fully exemptable. Sometimes an asset can be partially exempt, and that may influence your decision whether or not to file Chapter 7, where they would sell your stuff to pay your creditors, or Chapter 13, where you can keep your stuff, but you have to pay your creditors back over time the amount that they would have received if we had sold your stuff. So if you have stuff that's not exempt, then you might want to do a Chapter 13 and opt to repay those creditors over time. If you can't afford that, you may be stuck filing a Chapter 7 and you just take the hit of non-exempt assets that are then liquidated or sold for the benefit of creditors. But it's very important that you meet with a qualified bankruptcy attorney who can determine and plan those exemptions.